better.
Great.
This morning, we explored a number of interesting topics, some of varying degrees of, generality, but all really leading up, I think, to the whole question of how one balances environmental interests with other interests of society. And this brings us directly to the paper we're going to, or the presenter we're going to hear now, who will be speaking on the issue of environmental ethics and the law. And we're delighted to have with us, virtually with us, Professor Heather McLeod-Kilmurray, who is with the Environmental Law Group at the Faculty of Law, University of Ottawa. I would just note here that the Institute on a number of occasions has done joint projects, especially national conferences with the Faculty of Law at the University of Ottawa, so we're delighted to have them involved in this way once again. I should say that Professor McLeod-Kilmurray is also the founding director of the University of Ottawa's Centre for Environmental Law and Global Sustainability. So I will turn it over to you, Professor McLeod-Kilmurray.
Thank you so much, and I want to express my thanks at the outset for the opportunity to be with you in this way and to be part of this very important and exciting symposium. I can see a few familiar faces in the room. I can only see part of the room, but it's a pleasure to be with you in this way. Aussi, je présenterai mes remarques en anglais, mais j'accepterai avec plaisir des questions ou des commentaires en français pendant ou après la présentation. So I think I'll propose to speak for about half an hour so that my colleague, Mr. Lavianos, can speak for half an hour, and that'll leave us some time for questions and discussion. So the question for this paper is why would we want environmental ethics in the courtroom? I guess one answer is that it's fun to delve into the realm of philosophy for a change instead of being overburdened by the heaviness of black letter laws, one easy answer. But the real answer is that although law often argues itself to be a fully objective science, the reality is that ethics are clearly contained in law. There's ethical underpinnings to legislation. You can find ethics underlying the common law rules that are being applied in environmental cases. Often the arguments of the parties before a court or tribunal will expressly or impliedly include ethical positions or preferences. And also the judges may bring to bear, again, expressly or impliedly, ethical positions in relation to the competing interest in environmental cases. So since law involves values, priorities, principles, and environmental issues are often not just legal, scientific, political, or economic issues, but also ethical issues, it's important for judges and jurists to be familiar with some of the insights of environmental ethics. Considering the unique elements of environmental challenges and problems, thinking about this is also a useful opportunity, I think, for jurists to inquire into the ethical underpinnings of law and to perhaps add or change certain elements of legal principles, legal concepts, through the use of environmental ethics. So, for example, the traditional approach in Western culture to the environment, which is often translated into our approach to law, tends to take quite a strongly anthropocentric and utilitarian view of nature and human relationships with it. So as McGonigal and Ramsey have put it, for example, as part of the modern, Western, developed, democratic world, environmental law is inherently embedded with many of the paradigmatic assumptions of that world. Relations between humans and nature are divided, hierarchical, and utilitarian in character, even when we are protecting the wilderness. Other similar critiques involve, for example, an overemphasis on science in environmental cases, what's called the virtual monopoly of science-based knowledge over other forms of local or traditional knowledge, and inquiring whether law facilitates this monopoly or could help to challenge it in appropriate cases. Finally, McGonigal suggests that there are many hidden ways in which law underpins unsustainability. How does law support a culture of individualism and entitlement rather than communalism and responsibility? How does law position humans as separate from and dominant over nature rather than dependent on and integrated within it? So it's interesting to observe that facing environmental challenges in other disciplines has caused new branches to emerge. So there's now a field of inquiry known as sustainable economics, a field called political ecology. So maybe an introduction to environmental ethics and embracing of some aspects of environmental ethics could lead to a kind of legal ecology, or what David Boyd calls sustainability law. This could lead to new ways of envisioning judicial reasoning and analysis that might be helpful in achieving justice in environmental cases. So I'll very, very briefly, for those who may not be familiar with environmental ethics, give a quick history and definition of some of the main branches and insights of environmental ethics. And I propose after that to try to look for them in some Canadian environmental legislation and case law. So ecology and environmental ethics is a rich and varied literature. It's generally dated to about the mid-1970s, and it defines itself in a variety of ways. A useful definition is that it's a relatively new field of philosophical ethics concerned with describing the values carried by the non-human natural world and prescribing an appropriate ethical response to ensure the preservation or restoration of those values. So I think this definition is useful to ethics in law because it clearly sets out how it's appropriate to judging. It calls for the use of environmental ethics to describe the issues at hand in particular cases and the competing values that are at play in each case, helps us to identify them clearly. And secondly, hopefully, ethics can help to prescribe solutions to these environmental disputes and environmental dilemmas by applying these ethical valuations to the facts and the law at hand. So mainstream environmental ethics is sometimes regarded as an extension of human morals to new entities. And some of the main areas of emphasis are to underline the difference between anthropocentrism and ecocentrism. So anthropocentrism obviously regards the environment mainly as a tool for humans, what benefits humans can get from it as resources, as economic resources primarily, something that can be exploited for human benefits. Some argue that weak branches of anthropocentrism can help to achieve environmental protection by extending human morals to future generations, to broader aspects of human interests such as beauty, health, culture, and not purely resource consumption, while others say that a move to a strong version of ecocentrism is essential for us to truly achieve environmental protection. Another area that environmental ethics tackles is the idea of who is worthy of respect or consideration. And how can we perhaps prioritize competing interests in this way? So it's a traditional philosophical question. What is the criteria for being valuable or morally considerate? Is it the ability to suffer? Is it sentience? Is it consciousness? Or is it mere existence? So the very famous article by Christopher Stone, Should Trees Have Standing, for example? Should we treat trees as having rights? Are they entitled to rights and protection in the same way that humans are? And rejecting this concept is sometimes called speciesism. So it's a kind of discrimination that prioritizes human rights over the rights of other animals and that neglects the inherent value of ecosystems, of species, of environmental objects. Another thing that's often raised by environmental ethics that can be useful in environmental cases is the emphasis on individualism as opposed to collectivism. So the rights-based discourse that we have, the human rights-based discourse as a prime example, is frequently cited to be very individual-based. Although it's very important to note that individual human rights, when they are protected, lead to a great deal of communal benefits as well in terms of society and the values that it wants to protect. So they are certainly interconnected. But environmental ethics helps with debates, for example, as I've cited in the paper, with wildlife resource management issues such as, do we cull individual members of a species where there may be some overpopulation in order to protect the good of the herd, or in order to protect other species or the ecosystem itself, or is any individual life more important than the collective? So these are kind of insights from ethics that can be useful in cases when we're trying to determine issues of that kind. For example, it can be relevant to procedural issues in litigation. So a more collectivist or communal approach to environmental problems could lead courts to be more friendly, perhaps, to applications to certify class actions, whereas an emphasis on individual damages, individual remedies might lead a court to be less inclined to certify and to prefer to hear environmental health harm cases on an individual basis, for example. So that's a very practical implication in law of this sort of highly esoteric philosophical debate. Apart from those mainstream issues of environmental ethics, there's also some much more radical and alternative approaches that arise from environmental ethics that are interesting to explore. Perhaps one of the most radical is an area known as deep ecology, and it argues, perhaps like the critical legal theorists, that nothing will do but to scrap everything and start all over again. An entire rethinking of all aspects of economy, politics, society, and law. Our whole way of living is essential. So that might not be the first thing that a litigant would want to propose in a courtroom, but it's one that's available perhaps over time as an evolution of the role of ethics in environmental law. But its interesting concepts include the idea that humans, that a very strong emphasis on the idea that humans are not separate from nature, that nature has intrinsic value, and a general idea that we should perhaps be more cognizant of the equal value of humans and the environment that we depend on. So to reduce this hierarchical thinking that's quite prevalent in environmental law. So this is a major paradigm shift that's sought by these philosophers. Two fields that are perhaps much more judge-friendly would be the branches of environmental justice and ecofeminism, which are two other branches of a sort of radical or alternative environmental ethic. So ecofeminism emphasizes the connection between the oppression of women and the oppression of nature. So the courts have been highly made strongly aware of the effects of discrimination, the systemic nature of discrimination, and the inadvertent harms, the differences between substantive equality and a more simple version of equality. So taking these areas of knowledge that have come to the forefront of judicial education and judicial thinking, ecofeminism emphasizes that these same structures that lead to harm and degradation to women are often many of the same structures that lead to a disrespect and harm for the environment. And that overcoming these dualisms, such as between masculine and feminine, human versus nature, reason versus emotion, objectivity versus subjectivity, overcoming some of these barriers could help in leading to a more protective environmental ethic. Environmental justice is a field of law that's much more developed in the United States, but comes from the idea of sort of eco-racism, based on a lot of empirical evidence showing that many of the most harmful industrial facilities tend to be sited in low-income or racialized neighborhoods, for example, and why is that? So these concepts of racism, discrimination, inequality, and transferring them to the notion of environmental harms and environmental benefits and discrimination could be something that would be much more easily absorbed, I think, by the courts and are extremely important to emphasize. Just one final thing in terms of the environmental ethics themselves. There's an interesting concept that was developed by Klaus Balselmann called ecological justice. And he suggests that justice being the linchpin of the purposes of law, that in environmental cases, ecological justice is what we should be seeking, and that's based on 3 sub-branches. One is intergenerational justice, so that's the idea of protecting resources for future generations. Intra-generational justice, so the notion that it's discriminatory and unjust for certain members of the present generation to enjoy all of the environmental benefits and impose all of the environmental harms on others. This comes up frequently in the climate change debate, for example. And the third, and much less often discussed branch, is interspecies justice. So again, an ecocentric perspective, that we owe obligations, we owe legal obligations from a justice perspective to the other species that we share the ecosystem with. Finally, I just want to mention another radical and very closely connected to the legal field, a concept called green legal theory, which Michael McGonigal and his associates at the Polis Project on Environmental Governance at the University of Victoria are working on. And their goal is to examine the role of law in both creating systemic unsustainability and in impeding or facilitating its resolution. And so from their website, they discuss their project, and it's very interesting. It entitles this notion that legal and political institutions must offer much more than a discrete body of jurisprudence aimed at the protection or management of nature. Instead, what is needed is legal analysis that recognizes how the modern liberal state and society, including its environmental laws, are embedded in a governance framework of unsustainable legal and political economic doctrines and practices. And then the role of green legal theory would be to explore how such doctrines and practices might be changed to develop sustainability. So that's a more concrete adoption of these environmental ethical principles into a legal theory that could help with the evolution of environmental law. So these are some of the main offerings that an awareness of environmental ethics can present to jurists and to lawyers. And so I want to now just turn quickly to look at where we can find some of these strands of environmental ethics in the law. Are they express or implied? And do they have any effect on the ground, which is the most important question at the end of the day. So I've outlined a lot of this in my paper. Many environmental statutes in Canada contain environmental ethics, or at least in order to operationalize some of these ethics, rather than citing these more philosophical principles, often many of these ethics are embedded in environmental law principles, many of which you've been discussing earlier today and we'll discuss tomorrow, such as the precautionary principle, the polluter pays principle. The principle of sustainable development embodies the philosophical notion of intergenerational justice that we've been discussing, and so that's where you would hear that more in this concept of sustainable development or sustainability. So a couple of examples of legislation. The Ontario Environmental Assessment Act states as its purpose the betterment of the people of Ontario by providing the protection, conservation, and wise management of the environment. So that's a very strongly anthropocentric ethic that we find there. We're going to protect the environment for the benefit of the people of Ontario. So any environmental protection, any environmental good has to be justified in terms of human wants and human needs. A very contrasting approach can be found in other statutes. One example is the Federal Species at Risk Act, which provides that wildlife in all its forms has value in and of itself. So there's not necessarily a need to prove a human benefit in order to justify taking measures to protect these environmental resources. The Supreme Court of Canada has also recognized that you can use the criminal law power to legislate to protect the environment per se. You don't need to prove a connection to human health in order to do that. So that was a strong move by the Supreme Court of Canada to move away from a strong anthropocentrism and to indicate to judges that an ecocentric approach in some cases is appropriate. Okay. So in terms of case law, there's many examples. I've highlighted just a few in my paper. In terms of environmental jurisdiction, for example, you can note, again, it's not expressly stated, and this is a case from 1997, the Hydro-Quebec case. So briefly, the facts were that Hydro-Quebec was charged with dumping PCBs into a water source, And they argued in their defense that the Canadian Environmental Protection Act did not provide the federal government with the power to regulate toxic substances, and therefore they were not bound. So again, the majority held that this was a valid exercise of the federal criminal law power. And again, as I just mentioned previously, the court said that humanity's interest in the environment surely extends beyond its own life and health. And again, further stated that where the environment itself is at risk, whether or not the substances concerned pose a threat to human health, and whether or not the aspect of the environment affected was one on which human life depended, is a sufficient reason for legislating. So that was a very ecocentric approach. Another interesting case in the administrative law realm was the Imperial Oil case. So again, this was an example where taking note of environmental purposes and the superordinate importance of the environment, as the Supreme Court has underlined, led the court to interpret administrative rules differently in the context of environmental law. So in that case, it was an application for judicial review, and the court reasoned that the collective desire to protect the environment in the interest of the people and an emerging sense of intergenerational solidarity and acknowledgement of an environmental debt to humanity and to the world of tomorrow meant that it was reasonable to apply a polluter pays principle, and it read the conflict of interest rules in administrative law differently, saying that in the context of enforcing environmental statutory discretion, we had to take a different approach given the goals of the overall Quebec regime for environmental protection, and find that there wasn't bias in that particular situation because of the environmental context involved. So that was another extremely practical example of prioritizing the environmental context and interpreting the law as a result of that. Rather than just reiterating everything in the paper, I'll add on a few things that aren't there for some added value. In terms of environmental rights, how can the courts use perhaps existing legal concepts but incorporate some environmental aspects to them? So the Supreme Court of Canada has recognized that environmental rights do exist, although they're not contained in the Constitution, as we all know. In Ontario versus Canadian Pacific, the majority of the Supreme Court concluded that a fundamental and widely shared value is indeed seriously contravened by environmental pollution, a value which we refer to as the right to a safe environment. And other courts in other jurisdictions have gone further to actually interpret the right to life provisions of their constitutions to include a right to a safe environment solely through jurisprudence, not through constitutional amendment. So that's another aspect of judicial power in terms of incorporating environmental ethics into the law. So, for example, the Supreme Court of India has established that the right to life in the Indian Constitution includes the right to an environmental quality adequate to sustain life. So in a case called Indian Council of Enviro-Legal Action versus the Union of India, the court stated that by virtue of the constitutional right to life, the court had jurisdiction to require environmental regulators to clean up unsafe groundwater pollution as a human right, as part of what we would call Section 7. So the Canadian courts have not gone that far, but this is something that's possible by incorporating this ethic into Canadian law, for example. So environmental ethics will not lead courts to one correct answer in every case, but they can help to enlarge perspectives about what's valuable and what's not. It will change what is perceived as relevant and irrelevant, what kinds of harms are reparable and irreparable, and how we balance the competing interests in environmental cases, and even more, how we choose and justify these new balances that we may come to as a result of these new insights. So by playing a part in environmental law, courts can also inquire into some of the underlying ethics in common law rules, in legislation, in constitutional principles, and bring some of these to bear in the litigation before them. So just to conclude then, these environmental ethics may also make courts more likely to actually enunciate the ethics and values that they find in statutes, in case law, in the arguments of the parties, and also in the reasons that they provide. This can lead to greater justice in environmental law decisions and outcomes, and even more broadly, because these environmental judgments, I would argue, are essential to the evolution of cultural perceptions and priorities in environmental protection, a judicial engagement with environmental ethics might lead to a greater social engagement with them as well, to have a broader impact on environmental protection in society generally. So those are the comments I wanted to offer, and I'd be very happy to answer any questions or hear any comments.
Thank you very much. We will, of course, take questions and please submit them. There's one coming already. While those are being collected, I wonder if I might just return to a question that came up this morning in the context of sustainable development, and it I think is appropriate here. And the question really related to whether or not Canadian courts, Canadian judges, even have the language to talk about environmental rights independent of human values. Can we even talk about that? And it occurred to me later, as I was munching a sandwich at noon, that judges have faced a similar problem in terms of incorporating Aboriginal perspectives on environmental damage, for example. It's a problem of actually a whole language, that a legal culture that can accommodate that. And I wonder if you have any thoughts on that, Heather.
Yeah, I think well, two things come to mind. One is that's exactly the point, that some of these doctrines, such as common law doctrines that are so well established as being sort of created for an opposition between two individual opponents in litigation, are just not the kinds of things that were developed to deal with these more collective issues, these long-range matters. And so, yes, I think that's one of the things that the language and the concepts and the frameworks that we use need to expand to accommodate that. But it's also interesting to note that it's true that the courts themselves have asked for help with this. So in the well-known Canfor decision, for example, when the parties asked to have some of the damages be calculated to account for the inherent value of the trees being lost in addition to their stumpage value, the Supreme Court said, we like that idea, we'd be open to it, but you haven't presented that to us. What is the value? How would you calculate it? So they expressly recognized that there was an inherent value to this environmental resource, but needed some help with figuring that out. So perhaps some of this goes to judicial education, to enhancing the vocabulary that we have for these sorts of things through environmental ethics and principles. But some of the burden, I think, also lies on the parties to bring these arguments forward. I think the courts have indicated to some degree their willingness to hear this and would like some assistance from the parties.
Thank you very much. The first question from the floor, and actually follows fairly nicely on this. Rumor has it that Section 35 of the Fisheries Act may be amended to remove protection for fish habitat and replace it with a protection for fish of ecological, cultural, or economic value. How would you evaluate these criteria from an environmental ethics perspective?
Well, I guess the question always is, too, that it's important for us to have these environmental ethical tools available to judges, because it seems that those criteria are very much subject to subjective analysis. So who's going to decide whether or not they have such value? I think it would be stronger if somebody could attempt to define what those values might be or how they might be evaluated, rather than just leaving it to a general interpretation.
Okay. The next question is one that deals with practicalities. And it's interesting, some of the balance of the questions here. Some are at a meta level, and some are more concerned with practicalities. And the question points out, look, we have to eat, therefore we have to kill and harvest. We are concerned about things like pesticide use, genetic modification of food sources, human health, interference, overpopulation. Basically a menu of big items. And I think the question is why are we worrying about environmental ethics at the level that we've been talking about today before we've addressed some of these big issues, the fundamental issues. It is, if you will, the sort of the practical view of where we should be devoting our energies. So I will open that to you.
Yes, in 5 minutes or less to answer that question. Well, I think one of the things that we can say that environmental ethics invites us to consider also is the short-term versus the long-term view as well. So immediately pressing concerns that need to be resolved, I think environmental ethics invite us to think of the long-term view as well. So if we speak about genetically modified foods, for example, because of an urgent need for food at the moment, is experimenting with genetically modified foods in an open-ended, open-field way, given the state of hunger in the world right now, something that's going to resolve that problem immediately? And is it going to remain a solution over the long term, or is it going to exacerbate the problem at the end of the day? And also, in resolving these issues, what kinds of expertise, what kinds of inputs do the courts need? So often these issues are presented as extreme economic urgencies or as highly technical scientific solutions. And are the courts getting a broad enough perspective when they're called upon to resolve these issues to balance all of these competing interests in the immediate and the short term across these wide variety of areas? That's, of course, one reason why many people say the courts should not be doing this, that it's so multifaceted and complex that the courts are not equipped to do it. But given that these matters, such as liability for genetically modified foods, are coming before the courts and they are in the process of resolving them, it's important to have this variety of perspectives and to try to make the competing interests and values as explicit as we can when we're trying to resolve these problems.
Thank you. I'd like to return to another question that came up this morning in terms of intergenerational equity. And the question was put in terms of how do you measure which generations, how far along do you have to be concerned? People with an economics background would say this is about the social discount rate,
Right.
And I guess what would be interesting to hear is whether or not ethicists have any insights as to how we actually weight the interests of succeeding generations, which may be many, or depending upon your outlook, few, I suppose. But how do we actually go about that? Does ethics have something to tell us?
Yeah, that is a very difficult question, and it's true that the ecological economists have been looking into this, and there's been a lot of praise for and critique of cost-benefit analysis in terms of trying to put numbers on these things. But I think just the idea of incorporating that responsibility is something that's new, and it's important. It is actually trickling into the legislation. And for example, in environmental assessment law, making it an obligation of environmental assessment to at least inquire into the harm that will be done to the resource over the long term. Will this resource be able to recover? Will it be able to maintain itself, or will it be permanently damaged? Requiring that is new, and that's a step forward that has occurred. So there's many difficult technical, scientific, and economic questions in terms of operationalizing it. But just the idea that we've turned to this now is I think, an important improvement that ethics has brought to this idea of environmental protection.
Okay, thank you.
Also, I guess in terms of, for example, toxics regulation, the whole idea of the precautionary principle sort of brings into mind also this intergenerational equity, that we should be assessing the harm over the long term. We should be presuming things to be risky rather than presuming them to be safe. These are all things in terms of long-term future, I think, that are being operationalized on some level.
I have one last question, and that is with respect to something you mentioned in passing, and that is the idea of environmental justice or eco-justice. And in the United States, the concept of environmental racism, which has certainly attracted a lot of attention, I know, especially in the southern United States. One sees a number of situations where that has been raised. And you noted that there hadn't been a lot of that writing in Canada. I wonder if the whole concept of the fiduciary duty of the Crown towards Aboriginal people and some more general literature on Aboriginal perspectives on environmental law doesn't lead us directly in that sort of direction. I mean, we may use different language, but surely it's basically the same sort of concerns.
Yeah, absolutely. And I think the little empirical research, the growing but still small empirical research that's been done on environmental justice in Canada almost always focuses on Aboriginal issues, the issues of the concentration of POPs in the Arctic in mother's breast milk, the issues of the Aamjiwnaang First Nation and the gender birth of babies, the change there. Those are some of the areas that have been documented. And that's where part of the movement would start from. But it is, so that's a good start, and some of the constitutional rights of Aboriginal peoples might be a good way to start operationalizing that. But it is broader, and we certainly need more research on environmental justice in terms of economic groups, in terms of gender disparity. So there's a little tiny bit of research emerging about gender equality in the climate change debate, and whether some of the solutions that are being proposed will create other types of inequalities. The carbon tax in BC and the difficulty for lower income people to cope with that. So these ideas of environmental justice are becoming more prevalent in Canada, but I think there's a lot more work is needed. And that's something that courts should be very open to. That's not a whole paradigm shift to start talking about discrimination and equality. It's just adding on the environmental realities.
In some sense, then, one might say if the court were to take baby steps, these are the easier steps it might take in terms of refashioning a paradigm.
I think that's right. But again, if parties can bring this type of language forward and make the courts perhaps more comfortable and familiar, then it might make it easier to take more radical steps after that. Yeah.
Thank you very much. That's it, and we're on time. I'd like to thank you very much for your presentation and joining us from Ottawa, where you don't have the snow that we're getting, but we're a bit envious of what you've been getting there over the last few days. But thanks very much for joining us. We really appreciate it, and that was really a great talk. So thank you.
Thank you.
Okay. One of the themes that has come up, I think, fairly consistently, beginning with Professor Ali's talk this morning and continuing on into this one, is that the devil is often in the details. That is, the problem isn't necessarily articulating great principles, it's operationalizing them. And there are different ways of operationalizing them. And one of the interesting things about environmental lawyers is that they are willing to think of different ways of cutting the cake, if you will, of looking through the prism. And one of those ways is to think of environmental law in terms of human rights law. And someone who's been doing that for several years is Professor Nikki Vlavianos of the Faculty of Law at the University of Calgary. I would hasten to point out she started doing this under a project
was going to mention that.
With the
I am
Institute.
going to mention.
We had the great pleasure of having Nikki as a research associate over 10 years ago, and she continued half-time with the Faculty of Law until they stole her permanently from us. We still regret that, but we're getting over it. And we always enjoy Nikki coming down and talking to us, and both in an informal setting and today, to passing on some of that research, which I said she's been involved with for a number of years. So I'll give you Nikki Vlavianos.
Well, thank you, Owen. Thank you very much for that introduction. Thank you for inviting me to be here. Thank you to Environment Canada for sponsoring what is so far an incredibly interesting discussion today. So, as Owen started off and mentioned a little bit, I'm going to give you just a little bit of a background in terms of how I came into this topic. So I'm going to be speaking about the intersection of human rights law and environmental law. So we are now going to come down to that anthropogenic level. And I came into this topic because, as Owen said, I was working on a project at Searle, which was a project funded by the Alberta Law Foundation, which allowed us to look at various issues in the resources development context in Alberta, in particular the oil and gas development context, from a human rights perspective. And one of the things we uncovered really early on in our research, and this was about 10 years ago, as Owen says, it started 10 years ago, was that even then there were Albertans that we found sort of in news articles or in transcript hearings in front of some of the boards using the language of human rights, sort of in a very broad, vague, general way, for example, saying, we have a right to to breathe clean air, we have a right to clean water, or maybe even more generally, we have a right to a clean, healthy environment. So we set out, amongst other things on the project, to find out whether this sort of talk of human rights had any legal application in the resources development context, and in particular, of course, in the context of environmental impacts from that resources development. Now, of course, we all had a general sense that obviously there's moral impact here. There's a lot of people use the language of rights more from a moral point of view, but was there really any legal basis for using this kind of language in this context? At the time, so about 10 years ago, while there was a lot of relevant literature from other jurisdictions, there was some, but there wasn't a lot of thorough, comprehensive works that had been done by Canadian scholars. Since then, a number of Canadian scholars, including most notably David Boyd, who just published a large book with UBC Press, and also Linda Collins from the University of Ottawa, both of which have written very extensive, thorough treatments of the subject. So I do draw very much on their work in the paper, and also today, obviously, for the presentation. Of course, this is necessarily going to be a very condensed treatment of what is a very big topic, and it sort of goes off in a lot of different directions, and it raises a lot of different issues and challenges. So I'm just going to hit the high points, of course, and defer to some of those more comprehensive works, like David Boyd's book that was just recently published. So in a nutshell, though, the overall point that I'm going to make and that I hope to leave you with today is that there is significant evidence that decision makers, courts, regulators, litigants, scholars are increasingly viewing environmental impacts, so for example, air and water pollution, as potential human rights issues in some specific contexts. As far as the cases go, just to kind of give you a little bit of a flavor, and we'll get into this in more detail, as I note in my paper, there is current litigation that's begun in Ontario, and it was launched by EcoJustice. This is a charter test case where they want to put the charter issue front and center before the court. We have had, and I'll go through this later on, we've had some cases in Canada where Section 7 has been argued, but the courts so far have not directly, explicitly dealt with the question. So this EcoJustice court action that's been started in Ontario is alleging violations of Section 7 and Section 15 of the Charter in the context of exposure to toxics in Sarnia's Chemical Valley, which, as some of you will know, has a large concentration of chemical processing and refinery facilities. In Alberta, we've recently had at least two situations where either in front of the board or also in front of the board, but also in front of the Court of Appeal on a leave to appeal application, where landowners in the province have alleged violations of Section 7 of the Charter in the context of environmental impacts from oil and gas facilities. Internationally, there are several human rights bodies that have established quite a body of decisions, including, for example, the European Court of Human Rights, which has repeatedly recognized that human rights may be infringed by environmental harm caused by industrial activities. Domestically, our previous speaker referred to the courts in India, and the courts in India, for example, and in other countries like in Nigeria, have established that within their constitution, the right to life does include protection from environmental risks and harm, and that's under the right to life. So in Nigeria, for example, courts have struck down regulations authorizing gas flaring on human rights grounds. So those are just a few examples just to get us started. The main topics, the main issues that I want to go through today are on the slide. Firstly, of course, why even talk about human rights at all in this context? What's the point? What does it offer? As opposed to sort of the traditional environmental law approach. Why would we even want to go into the human rights realm? Secondly, what are the different approaches for using human rights in the environmental context? Most of this will come, you'll see, from my discussion of what's happening internationally. In Canada, as we'll see, the law really is in its infancy in this context, but of course, and we've already, when Professor Tolfsen was talking about the precautionary principle, there was, he alluded to the use of what's international law and even what regional tribunals are doing or what other countries are doing, often being used as interpretive aids when our courts are looking for guidance, especially when it comes to interpreting the Charter and interpreting the Constitution. So, and then of course I'm just going to, by that point you've already gotten a sense of what the current state of law is in Canada, but I will talk about that in more detail. And then by way of conclusion, just to note, obviously not all of them, but some of the key challenges to using human rights in this context. So the first question, why even use human rights in this context? Well, the first thing, of course, is just simply the moral, legal force of using the language of human rights. Human rights talk tends to get people's attention. It tends to give sort of weight and gravity to the discussion. In the environmental context in particular, it might be easiest to think about it in contrast to how environmental pollution is typically dealt with under traditional approaches to environmental protection. So how would approaching environmental pollution from a human rights perspective, how would that be different than the traditional regulatory approach that we use for managing and addressing pollution? So many scholars have exposed the differences between a traditional regulatory model and what a rights-based regime would look like. The traditional model, of course, we all know tends to be characterized by broad governmental discretion, sweeping powers, public interest calculations, and as well some procedural rights which allow, we've already talked about some of them today, certain stakeholders the right to certain information, the right to be consulted, the right to be notified, and potentially the right to be heard in a decision-making forum. By contrast, a true rights-based regime, scholars say, would be one which granted citizens clear substantive rights, environmental rights, that would have to be balanced against other legally recognized rights and interests. So, for example, property rights. And instead of a citizen coming to an environmental decision maker essentially as a supplicant, asking that decision maker to take its concerns into account in the public interest calculation exercise, somebody with true rights would have a different status. They would come as a holder of rights, and so there would be a level playing field, at least at a minimum, with other holders of other rights that are recognized, most importantly property rights. But also that in some cases human rights, not in all cases, but in some cases human rights will trump other rights. Why? Because the decision would amount to an unjustifiable human rights violation. So human rights don't always trump, but they have the potential to trump in some circumstances. Another reason for using human rights in this context is because of its post-decision application. So where it is believed that a decision maker has not struck the right balance in making its decision, in exercising its discretion, and that it has done so in a way that has violated fundamental human rights, the decision is potentially reviewable even by a stakeholder that was not involved in the initial decision-making process. So, and the literature is clear on this, and the court cases are clear on this, that a statutory decision maker's exercise of discretion is subject to scrutiny under the Charter. And as well, human rights provides a vehicle, of course, not only to perhaps at first instance influence an environmental decision or to challenge the decision, but it also provides an avenue to challenge regulations or standards that may have the effect of infringing upon fundamental human rights. So the second main question is, what are the different approaches for using human rights in the environmental context? Well, the literature reveals two main approaches and sort of three if we count them all. The first way is to approach this through the creation of procedural environmental rights. The second way encapsulates two different avenues, really, but it's the creation, the general category is creating substantive environmental rights, creating or recognizing substantive environmental rights, and doing that in one of two ways, either through the creation and or recognition of a freestanding right to a certain type of environmental quality, or recognizing that existing human rights have environmental dimensions that are potentially implicated. So let's break those down a little bit. Procedural environmental rights, we've already, I think it was our first speaker today, mentioned some of them. We're all familiar with these. So what do they include? Access to environmental information, participation in environmental decision making, access to justice in environmental matters. Those are sort of the big three pillars. In Canada, federal and provincial law implements a variety of procedural rights in a variety of ways, often through the regulatory statutes, specific administrative regulatory schemes, the legislation that sets them up, environmental assessment legislation. Some provinces have environmental bills of rights. All of these basically in different ways provide members of the public with different ways, different avenues to be involved in a decision-making process or to challenge a decision that's been made in various ways. But most scholars who advocate for a true rights-based regime don't think that procedural rights in and of themselves is enough. Procedural rights, they say, get people to the table, and they allow people to be heard, and they sort of, get their voices there, but they don't place any outer limits on what decisions will ultimately be acceptable or not. And they also don't direct the course of decision-making in any obvious way. So most scholars writing in this area, obviously no big surprise, advocate for the recognition of substantive environmental rights. And in that regard, there are these two possibilities, either a freestanding right or recognizing that existing rights already, ones that we recognize, have environmental implications. So what do we mean when we talk about a freestanding environmental right? Well, the literature describes it in various ways. Sometimes it's referred to as the right to a healthy environment, the right to a safe environment, as the Supreme Court of Canada. This citation was already mentioned actually by our previous speaker. Or the right to a clean environment, the right to an ecologically balanced environment. You see all sorts of different language for it. The idea here is that this freestanding environmental right is one that extends beyond other existing rights. And the idea is that by virtue of being human, each person has a freestanding right to a basic level of environmental quality. Scholars who advocate for the recognition of this right will point to various international instruments which evidence the sort of evolving recognition of this type of right internationally, and many of those instruments are noted in my paper. They include human rights treaties, conventions, declarations, and this evidence also includes this body of decisions that's coming out of human rights tribunals, both at an international and regional level, that are really sort of talking about a right to a healthy environment. As well, David Boyd has cataloged that at least 90 national constitutions from around the world recognize as a substantive matter that their citizens have a right to live in a healthy environment. So despite this evidence, though, there's debate about whether a freestanding environmental right has emerged as a principle of customary international law, very much, I think, like the precautionary principle. There's consensus that it may be emerging, it's sort of out there. Some say that it has emerged, and if it has emerged, of course, we all know then it would form part of our law domestically once something attains that status of a customary norm. It does so, but I think the consensus, the weight of the authority is that it has not yet attained this status. In Canada, there's obviously no explicit recognition of this type of freestanding right in our Constitution. Even in the environmental bills of rights that we have in those jurisdictions that have them, none of them, according to the literature, really set up clear, enforceable, substantive rights to a healthy or clean environment. And we heard earlier this morning that Quebec in its charter does have a recognition of a right to a healthy environment, but the provision has some restrictive language in it, which scholars have said really would make it of limited effect. So is it possible that a freestanding environmental right may be implicit? Does it exist implicitly within Canada's Constitution or maybe within Canada's common law? Scholars, of course, hang on to this statement from Canadian Pacific, also cited in Hydro-Quebec by the Supreme Court of Canada, where the court said, you can read it on the slide, it was already mentioned earlier, but made reference to this shared value that they refer to as the right to a safe environment. So obviously those who advocate for it will hang on to this and say, we see the Supreme Court potentially moving there. It's unclear, obviously, at this point what the legal status is of this right in Canadian law. Should it emerge as a rule of customary international law, then arguably it will be part of Canada's common law. If we're not there yet, though, at a minimum, of course, it can serve as an interpretive aid. And all of this evidence that we see internationally can be used as an aid when courts here are construing and interpreting existing provisions in the Canadian Constitution and also in the relevant statutory legislation. And why do I say that? Because the Supreme Court obviously has, often referred to international law, both hard law but also soft law, even declarations, even things in, Spraytech. The Supreme Court didn't say the precautionary principle is a norm of customary law, but still referred to it as an aid in its sort of analysis. So, and the Supreme Court has said many times that the contextual approach to statutory interpretation requires our legislation to be read in a broader legal context, which includes any relevant values and principles expressed by the international community, whether they're binding or non-binding. So this obviously allows for a very broad interpretive function for the decisions that are out there where this right to a clean or healthy environment has been established. Having said that, though, the most established approach to dealing with and recognizing environmental human rights involves the recognition that existing human rights may be violated by adverse environmental conditions. So in other words, in a nutshell, the idea is that environmental pollution can impair and undermine various fundamental rights that most countries, including Canada, already recognize and protect. The most widely recognized human right of relevance, of course, is the right to life, which is stated in different ways in international conventions, declarations, regional treaties, national state constitutions, including Canada's Charter, of course, Canadian Charter of Rights and Freedoms. Scholars and tribunals have highlighted that the right to life is the most basic human right, and it is a prerequisite to all other human rights. And further to that, a prerequisite to the right to life is an environment of a certain quality. So environmental conditions or pollution or problems that endanger human life or quality of life implicate the right to life directly or indirectly. Increasingly, international and regional tribunals have been exposing the environmental dimensions of the right to life. And for example, there's more in the paper and obviously more in some of those longer papers that I cite, but just to give you a sense of what's happening internationally, the United Nations Human Rights Committee, for example, has stated in a couple of comments that in their view, the right to life, liberty, and security in international law has been interpreted too narrowly, and that it does include state obligations to protect from threats, including environmental ones, to survival or to quality of life. And in one case involving Canada, in fact, this is the EHP versus Canada case, the committee said that the storage of radioactive waste near homes raised serious issues with respect to state obligations to protect human life, and it directed the Canadian applicants to seek a remedy under Section 7 of the Charter. As my paper also notes, regional human rights tribunals have also concluded that the right to life may be violated in the context of environmental risks or environmental harm. And in particular, I've already mentioned the European Court of Human Rights has rendered several decisions where the right to life has been applied in cases of environmental pollution. In one case, for example, a complaint was brought about a chemical factory located close to the complainant's homes, which released large amounts of toxic substances. In finding that the government had failed to adequately protect the complainants in the circumstances, the court held that a violation of the right to life under the European Convention had occurred. Similarly, as we've said before, domestic courts in India, Pakistan, Nigeria have repeatedly said that in their constitutions the right to life protects against risks and harm from environmental impacts. So what's the current state of the law in Canada? Well, scholars agree. I think there's consensus on based on the scholars who have looked at the area, that the most fertile ground, the most fertile ground for a human rights claim in the context of environmental harm is in fact Section 7 of the Charter. And I mentioned that the Eco-Justice case that's before the Ontario courts right now is proceeding with a focus on Section 7. Section 7, of course, most of us know what it says. It's on the slide. Scholars like David Boyd and Linda Collins, who have studied this comprehensively and thoroughly, have concluded that based on the current case law on Section 7, that Section 7 undoubtedly does have environmental dimensions. And although there has yet to be a definitive ruling on the matter, the cases that have come before the courts where Section 7 has been mentioned in the environmental context have all hinted that a remedy may be available on the right facts. Such facts would have to evidence significant physical or psychological health risks or impacts. Section 7 has been argued in a handful of cases in Canada in the environmental context. These cases have, for the most part, been dismissed on other grounds. So the Section 7 issue was not directly dealt with, which is why Eco-Justice wanted to bring this test case to put the issue directly before a court. But here are just some examples of cases where Section 7 has been raised, just to give you a sense. So for example, there was an allegation of a Section 7 violation in a case where there was alleged harm, threats to human health posed by the operation of a waste incinerator. Another case raised the possibility of a violation of Section 7 by a government decision to locate a landfill near the plaintiff's homes. I mentioned 2 cases dealing with environmental impacts from oil and gas operations. It's been raised in the context of fluoridated drinking water, the health risks and impacts from fluoridation, and then the most recent, the EcoJustice case with respect to Chemical Valley. So as I said, in none of these cases has the court definitively decided and granted a remedy on the basis of Section 7, but at the same time, in none of the cases did the court say that Section 7 has no application in these type of contexts. There seems to be little doubt, based on that current Section 7 case law, which I'm not going to get into in any detail, that the case law would support protection in an environmental context. Section 7 case law clearly tells us that the right in Section 7 protects a right to bodily integrity and a right to be free from harm and from threats to that bodily integrity, including risks to health. So not just direct actual harm, but even risks to human health. And that Section 7 also protects against serious interference with the psychological integrity of a person. So scholars have noted that where a person has a credible or real fear of his or her physical well-being and safety, that personal security issues are likely to arise and may attract the application of Section 7. Of course, if we go back to the language of Section 7, just a reminder that just because you've made out a violation of the right to life, liberty, and security of the person, there is the next step, which is asking, whether the infringement is in accordance with the principles of fundamental justice or not. What are those principles? Most of us are very familiar with the procedural guarantees. So the right to a fair hearing, for example. But scholars have pointed out that these principles of fundamental justice also include some substantive elements as well, one of which is this prohibition against deprivations of life, liberty, or security of the person that would shock the conscience of Canadians. And scholars have suggested that some state-sponsored environmental harm may result in health effects that are so serious and wide-ranging as to shock the conscience. So no matter what procedure was used to approve of these activities, that they would be a violation of Section 7. So the key is that Canadian courts, in interpreting Section 7 in the environmental context, will likely be guided by international developments. And as noted, there's this wealth of decisions, this body of decisions coming out of international regional human rights tribunals, as well as domestic courts, including common law jurisdictions, where decision makers are holding that in certain circumstances, state-sponsored environmental harm can amount to a violation of the right to life. So these developments, it's anticipated, will be persuasive to Canadian courts. And in being persuasive, the next issue, of course, is going to be what are some of the challenges with trying to argue human rights in this context. Well, the first one, of course, I mentioned at the very end there, the term state-sponsored environmental harm. Of course, just a reminder that the human rights that we're talking about in this context applies to governmental action. So it allows for governmental action to be scrutinized, not private action. So in other words, this is a situation where the state, so a regulator or a decision maker, has approved of a particular activity, granting a license, granting an approval that is leading to the environmental harm or the impacts. So there must be a governmental action involved, a license and approval. Often there is, but it may not always be the case. So this, of course, will limit the application of human rights in the environmental context. Secondly, of course, there's the huge problem of scope, and this is usually where the criticisms start, which is if we start to expand Section 7 to include situations of environmental risks and harm, where do we stop? For example, will it just include actual direct threats or risks to human life itself? So, for example, risks of serious death or imminent injury, or would it include impacts on quality of life as well? So, pollution that affects, not necessarily directly means you're going to die or be seriously injured, but that it affects your quality of life in some way. And then, of course, the big challenge is proving causation and establishing harm in this context. Of course, establishing harm and causation in environmental context generally is always a problem. In this case, in the case of establishing that a charter violation has occurred, especially under Section 7, obviously the evidence has to be clear, overwhelming. It remains to be seen whether the evidence in the ongoing Chemical Valley case will meet the mark. So to conclude and just to sum up, I would just reiterate that internationally there's been significant sort of movement in this direction. In Canada, we're still in its infancy in terms of going in this direction. But as a matter of principle, as a matter of doctrine, there's really no reason, says the literature, say the scholars, as to why the Charter, in particular Section 7, may not provide a remedy in certain circumstances. But of course, there will be these challenges in any given case that need to be overcome. Thank you.
Thank you very much, Nikki. We'll open the floor to questions, and while they're being written, we already have some here. I'd like to begin with, I don't know if it's contrarian or provocative or just grumpy question, but it does, I think, it does arise directly out of a number of cases that we've seen with respect to Section 7 of a charter. And this come up recently because I've been doing some updating of Energy Resource Conservation Board here in Alberta, and they were considering Section 7, and they took, not surprisingly, a fairly narrow view of what rights meant. And I guess that leads me, and I was thinking about it at the time, is there a danger that when we use the language of human rights from the Charter, we're not essentially buying into a dialogue that doesn't necessarily help the environment? That is, you're phrasing rights in terms of not just individual rights rather than collective rights, but you're buying into a concept of rights that is relatively narrow. And the RCB was basically saying, unless it's an economic right or unless you're physically affected, it's not a right. And it's not a huge step from going to saying it's not a right to saying it's not an interest you have, or at least it's not a legitimate interest. And so I wonder if you have a question about that, how this reliance on really an 18th century approach to human rights, that rights are individual rights, and they're often centered in property interests or physical security. Does that, I wonder, advance more generally the cause of protection of the environment?
Well, I think there's two things. I think your sort of one point, I think, is the sort of the problem with the anthropogenic sort of approach, right, which is the big criticism in the literature to talking about human rights in this context. And that's why I'm assuming my talk followed right after the previous one, which is environmental ethics, so more the idea of looking at what's good for the environment per se from that point of view, as opposed to just from the point of view of humans. So obviously there's limitations with human rights as far as advancing environmental protection in a lot of ways. Scholars have said what may be good for humans may not necessarily be what the right thing is for the environment generally. About your point of the use of the word rights, I think that is exactly why people want to use human rights as opposed to maybe more just the word rights, which does traditionally in the common law conjure up property rights, economic rights. The Charter clearly does not protect just property rights. So I think that is why people, people in this area are looking at these. They're wanting to use the word rights more broadly, to expand it out, and I think that most regulators, in the province, I think I've seen it somewhere, would accept that the word rights in the statute does include all manner of legal rights. So rights that are granted, yes, at common law, but also rights, granted by the Charter. I mean, why wouldn't it? Why wouldn't the word rights include charter rights?
Okay. As a footnote to that, I think they did accept that they would include rights under the Charter. I think what the board has done is take a very narrow view of what rights the Charter gives you. So,
exactly.
And
but that's the next step.
The next the question that we have from the first question from the floor is actually goes right into this. Can everyone exercise a freestanding substantial environmental right, or just those persons who are directly impacted by the activity breaching the right? Is it an individual or a collective public right?
Oh, good question. I think the way it's developing internationally in those, states where they do have this right to a healthy environment, I think it is developing as an individual right. And so I think it is, the idea is that everyone, if it exists, which in Canada we know obviously we're not there yet, but if it does exist, that it will be a type of individual right, not a collective one. As far as the point about directly and adversely affected, well, that goes to really the scope of the right. So how do we define, where there's been a violation? Sure, we can say everyone has a right to a clean environment, but how do we then define whether it's been violated or not? And of course, that will depend then on how far we want to define the scope. And it may be that we want to say you need to have a direct impact. I mean, the adverse part of it, I think, is kind of implicit, right? I mean, you're not going to have, I think, an impact unless you're adversely impacted in some way. If you're positively impacted, I'm not sure people would be, would care necessarily. So, but certainly the idea of a direct link, a direct impact, and that goes to the causation part of thing. I think that's definitely part of this, right? If you're going to make out a violation of any right, you need to establish that you have personally been affected.
Okay. The next question relates to the right to a healthy environment and customary international law, and I just should say that this question sort of reminds me of a conference we had, probably 15 years ago on the environment and human rights. And I recall a distinguished European professor who was chiding Canada for not having a right to environmental health in the Constitution. And he said, for example, and as you've pointed out, a number of countries have done this. And then he listed about 3 or 4, and they're probably 3 or 4 of the most notorious polluters in the world. But to his mind, this apparently had solved the problem once you got the right in there. So this question actually
Nigeria, India, I know, these are the countries, right?
Yeah. The question follows sort of on that. If a right to a healthy environment exists as a customary international law norm, isn't the next question, what is a healthy environment? What is or would be the international standard to determine the international norm? Which I think is sort of a polite way of saying, doesn't this just mean whatever you want it to mean? But I may be reading into that, I don't know.
Yeah, I mean, I don't know if the international community would come together and come up with some type of international standard. I think obviously that would be very difficult. My understanding is that it just sort of develops on a case-by-case, decision-by-decision basis. And of course, this goes to scope, how big is the scope going to be, et cetera. But the reality is the right to life itself is a pretty big right. And it's been handled and it's been dealt with. And there are decisions where it's been applied, and even in Canada, right? So just to say that it's so big and complicated, we don't know where it's going to end, I don't know if that's the proper response.
Okay. The next question, perhaps the biggest hurdle facing the Ecojustice Chemical Valley lawsuit is establishing the deprivations of life and or security, etc., that they were not in accordance with an identifiable principle of fundamental justice. In the context of environmental rights, what principles of fundamental justice might have the best shot at winning this argument?
Winning which argument? That there's a violation?
That there's a deprivation not in accord with an identifiable principle of fundamental justice.
Yeah, so the Chemical Valley, I think what the question is getting at is the Chemical Valley case is a situation, as I said before, where the exercise of discretion is now being scrutinized. So the decision of the government to issue the approvals is now being scrutinized on the basis of the charter. So it's kind of after the decision. So in that context, you're right, there haven't been any procedural guarantees, that we can really point to. I mean, I guess the one thing we could ask is whether the particular applicants were notified of the particular application. Did they get notice? Did they have an ability to participate in whatever process occurred? What was the extent of that participation? All of those things. So those are the type of procedural guarantees that the courts will look at to see prior to government violating someone's rights, the right to life, liberty, security of the person. The court will look to see whether the person, had notice of the decision, had an ability to participate, had the requisite amount of information to properly participate, etc. But having said that, there are these substantive elements within those principles. So the shocking of the Canadian conscience that, in some situations, even where you have the procedural guarantees, the government action may be so egregious that we still don't think it should go ahead.
Okay. I have one last question myself, and it's because it's come up now a couple of times, the whole question of succeeding generations. And if you're talking about rights, as we've been talking about them under the Charter and so forth, what about our children, grandchildren, and so forth? What about those other generations? Have we essentially defined away their rights? Do they just not count under the Charter analysis, or do you think there is any room for arguing that rights can be read in for the succeeding generations? And if they can't, what does that do to sustainable development and its consistency with the rights approach?
Well, again, I think that's where you have human rights conflicting with environmental ethics in a broad sense, because I don't know, but I don't think, the language of the Charter is everyone, every individual. Usually that's interpreted to mean, that particular individual who's in front of the court. I'm not sure if it could possibly include future generations. I think that would be a tough argument to make. What does it mean for environmental protection generally? Well, I think it's just another avenue. I don't think human rights solves all the issues, obviously not, but I think it does provide some stakeholders in certain situations with simply another tool to have their concerns addressed.
Okay. Thank you very much.
Thank you.
Okay, we're going to do a break now until 3:15. Councillor Cass. Thank you. sorry.
With your last question,